Good afternoon. We are going to ask you to continue your lunch while we start the panel, because we have 5 more really, really wonderful speakers. All right. I have the privilege of introducing our panel moderator, Mr. Marvin Johnson. We are honored to have him here today. He is well known throughout the state for his work and reputation in the ADR field and nationally as well. He's the founder and executive director for the Center for Alternative Dispute Resolution. He's taught, he's trained, he's lectured extensively on dispute resolution, in addition to his broad experience in arbitrating and mediating thousands of cases. Marvin has received well-deserved recognition for his commitment and contribution to the field of AVR, far more than I can list here, but he is the recipient of the Maryland State Bar Association section of dispute resolution, Chief Judge Bell Alternative Award for outstanding contribution to ADR in Maryland in 2010. Welcome, Marvin.
Thank you. Thank you. Going with the theme, I guess some of you have already said to me, I've got a rock-style panel here. Rockstar panel, and I'm going to introduce them briefly. Had to cut short a lot of the information on their bios because we don't have a lot of time, and I apologize for cutting anything out. If anyone thinks it's important, when you have the floor, you can definitely add it. What I will say from the onset is that this diverse panel that we have here is unique in terms of this perspective. We're going to have perspective from the bench, from the researcher standpoint, from the educator/professor standpoint, from the trainer, from the practitioner, and from the program administrator. We've got all that, and we only have 4 people there. So some people are doing a number of different things, including myself. So let me, without further ado, get to the panel. It's almost in reverse order the way I printed it out, but let's start with, to my right, we've got Jonathan Rosenthal. He's the macro director. And its mission, as you know, is to promote the availability, use, and quality of ADR throughout Maryland. I think from why we're here today, you can see that macro is definitely doing that. Previously, Jonathan was executive director of ADR programs for the District Court of Maryland and has been solo practicing attorney and a mediator. He's an adjunct professor teaching negotiation, arbitration, and mediation at Anne Arundel Community College, and has taught mediation and at the Mediation Clinic at the University of Maryland Francis King Carey Law School right here. Jonathan was honored, as was I earlier, it was said, to be the recipient of the Robert M. Bell Award for Outstanding Contributions to ADR in Maryland, presented by the Maryland State Bar Association. Next to Jonathan, I got to flip around in my little book here, we have Professor Lisa Blomgren Amsler. She's the Keller-Runden Professor of Public Service at Indiana University School of Public and Environmental Affairs in Bloomington, Indiana, and Senior Saltman Scholar at the Williams S. Boyd School of Law, University of Nevada, Las Vegas. After practicing labor and employment law, she joined the faculty of Indiana University. And a lot of people know Lisa's from this next thing I'm going to say. From 1994 to 2006, she served as the director of the National Redress Evaluation Project for the U.S. Postal Service, analyzing data on mediation and employment discrimination complaints. Her research focuses on voice and governance and conflict management, including dispute system design, dispute resolution, collaborative government, and public engagement. Ms. Amsler received a National Research Award from the ABA, the Association for Conflict Resolution, the the International Association of Conflict Management, the American Society of Public Administration, and the Labor and Employment Relations Association. She's co-edited 3 books with Rosemary O'Leary and published numerous articles and book chapters on dispute resolution and collaborative governance. Next, we have Judge Dorothy Wilson. She's Associate Judge in the District Court of Maryland. She began her legal career as a litigation associate, representing the Department of Social Services in termination of parental rights, guardianships, and adoption proceedings for severely abused and neglected children. She taught at the University of Maryland School of Social Work as part of a state certification program for child welfare cases and served as secretary on the board of directors for the Baltimore County Court-appointed Special Advocates which advocates for foster care children. In August of 2001, Judge Wilson was appointed to the District Court of Maryland, Baltimore County. Since her appointment, she has served on several judicial committees, including Domestic Violence Subcommittee, Self-Represented Litigations Committee, the Public Input Committee, Self-Help Center Advisory Board, and the Macro Advisory Board. She chaired the Alternative Dispute Resolution Committee, the District Court of Maryland. She's currently a member of the Board of Directors, Judicial Institute of Maryland, and a member of the Alternative Dispute Resolution Committee, Judicial Council, and chairs the District Court Alternative Dispute Resolution Subcommittee. Last but certainly not least is my dear friend, Dean James Alfini. He's Professor and Dean Emeritus at South Texas College of Law, where he teaches constitutional law, mediation theory and practice, professional responsibility, and other related courses. He's also Professor Emeritus at the Northern Illinois University College of Law, where he was dean from 1991 to 1997. Before that, he was a member of the law faculty at Florida State University. We also served as Director of Education and Research for the Florida Dispute Resolution Center. He served as chair of the American Bar's Dispute Resolution Section, is where I know him best, and he's chair of the Association of American Law Schools and Alternative Dispute Resolution. I will add that Jim was on the first task force for the standards of practice for mediators that we all follow now, and he didn't have it there, but I remembered it and asked him, and so I'm including that right now. His publications in the ADR field include the co-authored Mediation Theory and Practice, a law school textbook published by Lexis Law Publishing. He serves as a delegate from the Dispute Resolution Section to the House of Delegates of the American Bar Association. So that is our esteemed panel. I am here to just ask a few questions of them and let them respond, ruminate. I don't know if we'll have time, but if we do, we'll take questions from the audience. So, first questions focus on the broader study, which I call the broader study, about the impact of ADR on responsibility, empowerment, resolution, and satisfaction with the judiciary. I'll ask the panel to respond from that particular report. What was notable to you? What stood out to you in that particular report? I know that for those of us who've been around the field, some of the stuff we intuitively knew, but there was no study to bring it forth. So
Marvin actually just touched on one of the things that I think is really important about this study, and that is that there are certain things that we knew intuitively, but we didn't have the research to support so that people could express themselves, so that all issues got resolved, because we know in mediation they can talk about all of the things that they want to talk about. The thing, though, that I think struck me the most has to do with probably my connection to the judiciary. I've been with the judiciary for almost 15 years, and I've heard 4 chief judges independently make a comment, something to the effect of, as the third branch of government, it's critical that the public have trust and confidence in the judiciary. And when you look at one of the results of this portion of the study, what you see is people who reached agreement in ADR were more satisfied with their experience in the judiciary, in the judicial process, than people who reached an agreement on their own, as people often do when they're going to court. They reach settlements before they ever get to trial. And what this suggests to us is that because the agreements that were reached in ADR were the ones where people felt more satisfied, that tells us that it wasn't important. I mean, it was important that they reached an agreement, but the differential was that those that reached an agreement using a process that was offered to them were more satisfied with their experience. And if we want people to continue to have trust and confidence in their experience with the courts, giving them the opportunity to use ADR is something that we need to continue to do.
Well, you said it far better than I ever could. My perspective is how broad the whole of the study is and how many different contexts and program designs that the study looks at. And that contribution is huge, allowing us to see how dispute resolution works in a variety of contexts, and in the one institution in government that the public may still have some respect for. And I think about the role of the courts. A friend of mine, John Gastel, who is at Penn State, works on deliberative democracy, dialogue and deliberation. And we usually think of that in connection with the executive branch or local government. And he was on a panel with Judge Posner of the Seventh Circuit. And the panel was asked whether there is any institution where the public truly deliberates as part of government. And Judge Posner said, no. Deliberation isn't built in anywhere for the public. And John Gastel turned and said, but Your Honor, what about the jury? And he said, he hesitated, and then he said, oh, except there. So this whole question of how the public perceives government writ large and where it gets to exercise voice and what its experience is when it exercises voice it's a critical contribution that the judiciary is making right now that the other branches are not necessarily doing as successfully.
Well, coming from the perspective of a district court judge for now nearly 15 years on the district court, and looking back over my years as a practicing attorney, one of the aspects of this research that I found perhaps the most surprising is knowing that different strategies are more or less effective as it relates to the ADR process. And one of the strategies in our last session that we talked about extensively that seems to be less effective is the caucus strategy. And that's the one that, as a practicing attorney, I've had the greatest experience with, and the one that I think looks a great deal more like, unfortunately, I would say, a standard court practice. And I found that to be very interesting because other strategies, which sometimes take longer, such as reflecting and eliciting, create a circumstance where the participants are less likely to have to come back to court for an enforcement action, are more likely to produce an agreement through an ADR process, are more likely to report that they're satisfied with the court system and the court experience overall, and are generally, I think, have a higher level of satisfaction overall. And I found that to be very interesting from this study. I know that oftentimes in settlement conferences and other forms of ADR process, the caucus is something that's used maybe perhaps in ways that from this study we can learn differently how it should be used. So I was very impressed and learned a great deal from that aspect of the study.
Thank you, Judge Wilson. We're going to come back to that when we dig deeper. But Jim, on the overall, the broader picture?
Well, under the general heading of things that we might have known intuitively, but aren't we now glad that we have all that data to support it? I'd sort of like to build on what the judge just said, and the caucusing findings I found most helpful along those lines, particularly the fact that people were more likely, as a result of caucusing, to say that the mediator respected and listened to them, but they'd feel more hopeless about the situation after mediation than they did before, and they report feeling less likely that they can work with the other parent than they did before the session. This is in the family context. That's particularly important to me in Houston, Texas, where the joint session has not been just marginalized, but it's become a dinosaur. In most family mediations in Houston, the parties are put in separate rooms and they never bring them together. There's no initial joint session, there's never a joint session. And now I've got data to bring back to Houston to try to convince whoever will listen, and I'm trying to think of strategies for doing that, that that's not a good idea, that maybe we want to consider joint sessions and we can speculate as to why that's come about. I think in large part it's because of lawyer colonization of the family mediation field, but there's other factors working there as well. So I am just so pleased that the people here in Maryland have done the good work that they've done, because it gives me some ammunition to use out there in the streets.
Thank you. I never thought of you being out there in the streets, but okay. Thank you, Jim.
Well, I'm Italian, you know. In fact, when I asked Jonathan if I could eat up here, he said, no, we're going to eat down there. And I said, yeah. Have you ever watched a Sopranos episode? They plan all their stuff over meals, you know. Even whacking people.
So now what I'd like to ask you folks a question, and I know we've kind of dipped into it a bit, but I want to drill down a little bit in the other two reports that drill down into the components about the strategies of mediation and the strategies of mediators and the likely outcome. So I'd like you to talk about, and I know it's already been started here, but that's okay, talk about what strikes you about the outcomes of that research.
You start. I'll go first again.
Yeah, we'll just go down the line unless someone wants to take it.
I think everybody has talked about the caucus, and I think it's something that's very important in terms of how we not only teach people to be mediators through 40 hours or more of mediation, beginning basic mediation training, but it's what we do with continuing education. And so I think the caucusing part is what struck me the most, because we watch what goes on, particularly in our court mediations. I can't speak as much to what's happening in the private mediation or private ADR field. I can speculate, but I can't speak directly to it. But I do know that in our court programs, where we know people rush to caucus, or, as Jim mentioned earlier, sometimes the attorney influence, when they walk into the room, say, all right, so you've done the introduction, can we just go to our separate rooms? I think this is a key component that we need to understand, which I feel like that today is helping us understand it, and then figure out how to reteach or teach better our continuing education components, so that people really begin to understand what the downsides of moving to a caucus might be and staying in a caucus, and what the upsides of keeping everyone together might be. On top of that, beyond just the teaching people the benefits of doing one or the cons of doing the other, one of the things that I think we have here in Maryland are relatively clear understandings of the processes that are spelled out in our court rules. And I think that's fantastic, but it's also something that we may know from the court rules, but we don't inform the public about, and we don't, I think, hold attorneys to task in making sure that they know the differences, understand the differences, and the benefits of each different process. And for me, that's to say that perhaps not all cases should go to mediation. Perhaps some cases belong in a settlement conference where a continuing caucus might be the way to go, or where offering or telling or directing strategies are the appropriate strategies to be used. So if we understand what's the relationship in this case, is it one that exists, one that needs to be preserved, or is it one just a matter of these folks got into a fender bender and they need to resolve the case and then move forward, and there is no relationship? Let's identify the distinctions and allow those cases, those parties and their attorneys to choose the process that's going to work best for them.
Before I make those specific comments, I just want to check. Can I sort of back up and react to the rock star comments of earlier this morning?
Please.
Okay. So I want to explain why the state of Maryland as a whole in this field is a rock star. I don't know how, most people in the room, I'm hoping, remember, you're the only, Maryland is the only state that, to my knowledge, did an organized, system-wide dispute system design exercise to come up with the structure that you have now, with the help of Nancy Rogers, for a state office of dispute resolution that has now grown into your community mediation structures, as well as the structures in your courts. And so you start with having better state infrastructure systemically, up and down the food chain, I think, than any other state, although California is pretty great. There used to be state offices of dispute resolution in Massachusetts and in Oregon. They're gone. Understand how important that is. And so you've got this infrastructure, and now this piece of work is the gold standard in terms of research design, and it is the best piece of work we have for all the other states in the union to look at in terms of empiricism across a variety of designs. And so that work needs to be widely shared. And in case I don't get a chance to say this at any other point, in order for it to get widely shared, yeah, sure, it's great to have it on the website. That's terrific. But it is largely a theoretical, and it is not anything that the scholarly community, which then teaches the next generation, will necessarily see in that format. So part of the problem is you've got all these wonderful researchers who have done this fabulous work, and they've learned a lot about specific designs. And I focused more on the family report, and I'll make a specific comment about that. But I would urge you, it takes time and resources not only to collect the data and to write these initial reports, but it takes time and resources for your wonderful researchers to publish these reports, and there are going to be lots of bites, right? You've got these 200-page reports. They're going to have to be broken down into digestible bites for the rest of the planet. And I would urge you to fund them for that purpose. So having said that, the thing that I was interested in terms of that wonderful 2-page handout and the rest of the family report was the emphasis on the relationship between the disputants, which is the closest issue, of course, to my own research with employees and employers at the Postal Service. And I found it deeply satisfying to see a number of findings even though there were no mediators who self-described themselves as transformative. And I should make it clear, I don't personally advocate any particular model of mediation. I think practice is a function of context, and mediators adapt depending on the context. In the Postal Service, the only reason they use transformative mediation is because this problem with the potential for bias in a system that the employer is designing for disputes to which the employer is a party, right? That's why the mediators were told, you're not allowed to tell somebody what the strengths and the weaknesses of the case are. And yet here is a study on the courts in which it turns out that telling people who's got the stronger case and who's going to win and who's going to lose doesn't really help things a whole lot. And that actually giving people a chance to talk and inviting them to talk and keeping them in caucus, all of which are hallmarks of transformative mediation, actually does seem to make things a bit better. So there is other research that is published research that reinforces this, but there's something in the literature called disputant interactional justice. There's a procedural justice literature, there's an organizational justice literature for employment, and in that second literature, this notion of the interaction between the parties ends up being important. And I don't think we see enough of that in court literature, and that was a huge contribution, I thought, in the family report.
Thank you, Lisa. Judge Wilson.
I pick up again on something that Jonathan referenced with regards to caucus. And that relates to whether, in fact, there might be certain types of cases where using caucus could be of benefit. This research just touches on that, and so I guess the next phase of research would need to delve a little further into that issue. But perhaps, as Jonathan has suggested, if the parties don't particularly have that kind of relationship that maybe wants to be preserved in any special way, and it is merely a matter of perhaps, as was referenced, a tort case or maybe a commercial type of litigation where the issue really does become one of value. Maybe caucus is something that can be used in that process to help the parties reach a resolution. That's the next step of research that I think would be on the horizon to expand what we've started to learn here through this research and grow it into new areas. I also think the education of users, that is helping the lawyers, helping the litigants to understand all of these different kinds of strategies, helps them to know which strategy may be best for their particular type of dispute. And I think there again, educating and training would help in terms of whether caucus is something that does serve a benefit. But again, I think our research needs to guide our thinking in all of that.
Jim?
As a legal educator, I'm just thrilled with the Maryland studies for reasons that we already discussed, but some others I'd like to mention. But before I go any further, let me encourage those of you in the audience who have been involved in the studies and so have some ownership as far as the data is concerned, to write some pieces for distinct audiences. And the audience I'm most interested in is the law student audience, the informed law student. Halfway through the semester, my students will know or have a sense of what you mean by elicitive and directive and reflective and certainly caucusing and telling. I mean, the lingo that's used in the studies is reflective of the literature on mediation, elicitive and directive. Those are words that Len Riskin uses in his second article, I think. The new old grid, I think, is where that comes from. And a reflective reminds me, is reminiscent of Bush and Folger's transformative writings. So the students will know or have a sense of what you're talking about. And if you could write a sophisticated piece, I'd love to use it in class, and I know you could. I'd also have the ammunition, again, to the students that take my class are generally third-year students. Many of them our law school is in downtown Houston, and many of them clerk in law firms or for the courts. And particularly in the family area, they'll come back and say, when we're maybe practicing opening statements or talking about the joint session, well, I never saw that. And they don't see that in the real world. And, we'll talk about that and why a joint session might be a good idea. But now I have data. Now, if you write that article, I can pass it out and tell them that, if your goal is you want the parties to like you as the mediator, then fine, caucus, and don't have a joint session. But if your goal is to offer the litigants, the parties, something of benefit to them, then you really do want to think about bringing them together and having a joint session. At any rate, thanks again for doing this research, and please write for a number of different audiences, particularly a law student audience. Thank you.
Thanks, Jim. When I was asked to do this, Jonathan didn't know whether to have me sitting over there or sitting here, and he says that you've done a number of various roles. So before we go down the line again and then open it up for questions, I want to take on what Jonathan started about the caucus and do a little bit on training, talk about it in the aspect of training. I did a piece, I've done a couple of pieces. This is kind of my last hurrah. Some of you know me for diversity and some other things I've done. This is my last hurrah in terms of, I'm glad you're doing this work about getting diversity of practice, which Lou had me work on and spun out a number of pieces for me, that we can understand the various, there's no one process better than the other, although I have a personal opinion of it, but all of them we can use and use them well under the ADR umbrella. But to the training point, let me just tell you a little bit about, I was given a plenary speech a number of years ago, a large audience, and talking about the caucus and the use of it. And not overusing it and when it should be used. And someone who had been trained by a particular group of folks said, after you do the joint session, you always go to the caucus. I said, that's not necessarily true. Yes, you do. Once you do your opening thing, you separate them and you go to the caucus. And I moved on without getting into an argument over a plenary presentation. But what I learned is that who trained you has an impact on what you do. Who trained you in their experience, in addition to your background, has something to do in terms of how you develop your practice and the strategies you use. And so I've always, in our training, I trained through the Center for Dispute Resolution that I created, which is going to be 30 years, and hopefully some of you will come to our 30th anniversary next June. But I asked the students in the training, is a caucus part of the process or is it a strategy? And they scratched their heads. And I said, it's a trick question. It's both. But you should use it as a tool and not as a crutch. You should know when to use it. When you caucus, you should know, why am I caucusing? And then after the caucus, could I have done this, gotten this information without going into the caucus? That's how you get better at being a mediator. But typically people just say, okay, caucus, and let's go do this back and forth. And there's some pluses and minuses of it, which we go through the training. I won't bore you with that now. But one should understand that someone in the session that Sharon led, I think Sharon said, we need to learn mediators need to learn how to get better. They get stuck in a rut and they think that they know all they know, and we all can learn and we all can get better and we can learn from each other. So I'm not gonna, Sharon took the mic from me before, so I got the mic so I can keep it, but I'm not gonna do that. I'm gonna ask the panel, is there anything they want to add before we open it up to the audience, to what we've said so far?
So real quick, from the court administration perspective, which is what I represent up here, what this research has done for us, I think, is opened our eyes to avoid the complacency in program design, right? Not just in our roles as practitioners, but in program design, to not be complacent with what we have and figure out how we can take what we've learned here and do better. It includes training, mentoring, and apprenticing our practitioners. It includes access to the services and a better understanding of the services for both litigants and attorneys and judges and court staff. All of those things got mentioned in our first session. And this research opens the door to all of that. How do we inform people? How do we give them the information? What do we say so that they don't fall into a defensive mode immediately? How do we open the door and bring them into the conversation in a way that they feel like they're constructively adding to the programs that we have in courts at all levels? And I think this research, all of the different aspects of it, is the entree to do all of those things. And that's why I'm so happy with where we are right now, having stuff on paper to talk about.
Anybody else want to add before we open up for questions?
Yeah, just one point, and it's sort of a continuation of the previous point. In order to build on what we have now, we need to make data collection easier and cheaper. And for example, the researchers went through case files and laboriously, in addition, I mean, this was the gold standard in terms of research design, because they gave surveys before mediation, they gave surveys after mediation, they gave surveys down the road 3 to 6 months. They observed people, they observed the mediators, they went through case files, they went through the history of the case. I mean, the observations, and the gold standard is triangulation. I don't know, I've lost count. It's well beyond triangulation. The problems nationwide and in every state is lawyers are not as advanced technologically as some other disciplines, and it's reflected in our data systems for courts. And the American Bar Association section of dispute resolution conducted a survey of all of the ADR state court administrators that we had on the email listserv, asking them what were the top 10 data fields they felt were important to collect in order to evaluate and market their programs. And that list is on the ABA website. If we could get every court collecting the same 10 data fields, we could then systematically compare dispute system design across programs, because it continues to be the case that we are in the thousand flowers bloom stage of wide variation from court to court. And that's why it's so great that you looked at multiple designs within your own state.
Thank you, Lisa. One thing I'll add before I open it up, Jonathan mentioned as well, I think goes to what Sharon was talking about in her session. He mentioned mentoring, and I'll add to that practice groups. I think it's so important because it helps with reflection. And I made this statement to a group the other day, we don't have enough reflection in terms of when we do our work, that's how we get stuck in a rut. And so by having a practice group, folks that you can talk about your cases and get some feedback, learn about some other things, I think it really, really helps. I mean, I have a practice group, though it didn't start out as a practice group, though some of you know Daniel Bowling, Homer LaRue, David Hoffman, call ourselves the Five Guys for a different reason. But when we get together, we always talk about cases that we had, what we did, what we could have done better, what would you do. It is so helpful in growing as a individual and as a mediator. So with that, I'm going to open it up for, we have any questions from the floor for our panel with respect to the work that's been done in their comments.
Good afternoon, and I would just like to say my name is Jeff Truman from the Baltimore City Circuit Court. I'd like to say I'm very proud of working with all these folks here in the room and on the panel, being from Maryland and having this research be as cutting edge as it is, and I want to thank everyone who's been involved over the years, and I know there's a lot more interesting research information to come, and I just wanted to reiterate what panelists have said, and that is it's case specific. Let's keep in mind that it's important to know what data tells us and to know that in some circumstances, caucusing may be a good tool. It's like you were saying, Marvin, that it depends on the situation, how cognizant, how aware are you of why you're doing it, and I think it's this kind of research that will help us grow as practitioners and us grow as court administrators to ask those questions. It's this kind of information that prompts us to go there. And so, embrace the dynamic that you're presented with. If you're there at the table, embrace the kind of dynamics you're presented with as a court administrator. I just wanted to highlight not only the diversity of thought, but the diversity of disputes that we are going to be administering and negotiating. So that was my only comment.
Thanks, Jeff. Yeah, there's no two disputes that are alike. Even if the fact pattern says they're alike, they're not alike because you got two different people coming from different perspectives, and you've got to manage that as well, dealing with the legal issues and other things that are in the room. Someone else. Very vocal group here. We got judges and lawyers and...
Well, Marvin, can I add just an additional thought, if I might, from the district court perspective? Just looking more broadly at this research, I just have to emphasize again, I know we've touched on it, but it really is just, for me, a thrilling point of the research, and it's just impressive to me. The notion that participants who go through an ADR process, regardless of whether they reach an agreement, are generally more satisfied with the court system is just amazing to me. And I'm glad this research proves that point. We've got the statistical, empirical data that shows it's of benefit, notwithstanding that the parties don't reach an agreement. And it also shows that there's shifts in attitude about conflict. So people begin to learn different ways of approaching conflict, which certainly helps the court system, because maybe their next experience won't necessarily land them in court, or it will help them to think of ways of resolving their next dispute other than through the traditional court process. Why is that beneficial? In the district court, we are handling such a volume of cases, and many of them do need the judge's trial time in order to resolve them. But if there are some that go the way of ADR, that's such a benefit to freeing up the time available for judges to address those cases that aren't going to resolve through ADR. And even if there's not an agreement through ADR, it helps the participants to think differently about their conflict. And I think overall, as the research shows, it inures to everybody's benefit. So I'm just thrilled that we've got this data to help support what everybody always knew. It's now here.
So I want to take a moment and thank you all for your remarks and for bringing so much to this discussion. As I'm sitting here listening, I am trying to think of some of the things in the research that haven't come up or haven't been discussed with the full audience. And so one of those is there is some information in the research that concerns the race and gender match between the participants and the mediator, and what difference that makes and what that says about the importance of having a more diverse mediator community. And so I wanted to put that question out, Marvin, to see if you or any of the panelists wanted to touch on that issue.
Yeah, Laura wrote about that was that 4 or 5 years ago? She did an article in the ABA Journal. I think it's important. I think that if you heed, because if I remember correctly, it was positive when you had someone who was of the same gender, race, etc., for the parties in dispute. And I think that's important. It's important for the field, because I think just like our jury needs to reflect the community, our mediators need to reflect the community. So it's important that we do that. It's always important that I say, when I do a lot of social justice work, and I always say, look around the room, because a lot of the nonprofits, believe it or not, they're not diverse. They want to do good work, but I look around the room and say, whenever you do a program, who's not here who should be here? That's what we need to think about. And in mediation, I think we need to look at our rosters and see who's not here that should be, who should be part of our roster. It seems that a lot of our community mediations are more diverse, but I think they could be better than some of our other rosters. Did I see a hand over here, Jim? Were you going to say something?
Marvin, I seem to remember that you and Maria Volpe and Sharon Press wrote an article for Dispute Resolution magazine on the diversity topic, and since I'm looking at Sharon here, I'm trying to entice her to say something on this.
Very good. Give her the mic.
Hey, thanks for calling me out, Jim. No, I share the perspective, and I appreciate that Laura did do that article previously that had the research that indicated the importance of making sure that the mediator pools are diverse. It is a challenge for program administration and a challenge for ADR programs, because there's a tension, and just want to put it out there that we always feel, and I wear multiple hats, I said in my previous session, and so from the program administration side of it, what I will say is the tension that you run up against is party selection and of who their neutral is going to be, and versus having the diverse pool. In Florida, we spent a lot of time working on diversifying our pool of mediators, our roster of mediators, but then we had to confront the secondary issue of just being on the roster doesn't mean that you get selected. Exactly. And so, how do you encourage, inspire, get to the people who are actually doing the selection? Again, I am very interested in the question of attorneys' control over the process and what that does, and I think that we have to always be thinking about how do we get to the people and figure out what it is that they want. And I think that this research indicates from a party perspective what means something to them. Attorneys will often say, oh, that doesn't matter, but they don't know that it does.
Does matter.
And so, I think we constantly have to come back to answering those questions of how do we check in with the parties always about what's important to them, and then how do we provide that kind of guidance to them.
Yeah,
and, including the research around what do they want, because attorneys always, I always hear it, attorneys always say, well, they want, what my client wants is for someone to tell them what they should do. And, I am so excited that we have research that says, no, that isn't what the parties want. That may be what you want, attorney. That isn't what your clients want. And so it sort of gives me an opportunity to make that secondary point as well. But the diversity of the mediator pool is critical and has been we've been talking about it for a long time, and we still have a lot of work to do.
Yeah, we do. As you know, Sharon, a few, through my center, we created Access ADR to try to give access. And I'll tell you this story. We wrote an article about it, and it's out there. It was in the ABA Journal, I believe. It was to get more diverse folks cases. And we did a real heavy intake piece, which got a lot of arrows in my back, and it got me called a lot of names because we didn't let folks in because we knew that the attorneys would say, we want someone that's very qualified that can handle. So we only got folks that were of a certain level. And we only took a few because we figured it was going to be difficult to get them cases. So we took 3 or 4, I can't remember, 3 or 4 people. And we had on our advisory board, we had insurance guy, we had an employment guy, 2 insurance people, employment guy, some folks from JAMS and other words. And do you know how many cases they were able to get these people? And there were only 4. Do you know how many cases they were able to get them in 2 years? 0. Zip. Nothing. The cases that were got were by me and by Homer LaRue, and there was only a few. And then the board said, wow, I didn't know it was this hard. And then we said, welcome to our world. This is what diverse mediators are up against, trying to get in and trying to get even a minimal case so they can prove themselves so they can get the higher case. So it is a problem. It's something that we need to work on. We shifted it a bit. We still have the program. We shifted it a bit, and we didn't go broad. We had funding, so they wanted to go broad announcement. We've kind of quieted down. We've got more people. They're getting cases. They're not the big cases, but that's what it takes to get it done. So I just tell that story because it's still something that needs to be done. And it came out of some research. It wasn't research. It was the typical research that Lork and them are doing good research now. But the anecdotal research was that it came out of a conference. We don't have a diverse panel. And we don't know diverse mediators, and we can't take a chance on someone because it's so important for our client. And so those factors, I think, still remain true, and folks tend to go back to the same people they know, they use because they know them and they're satisfied with them, and we've got to break through with that.
So I don't have a lot of answers on this one, but I do have a lot of questions thanks to the research, right? So it did touch on the idea that if a participant sees a mediator who looks like him or her, there's a positive correlation, a positive association. If it's a co-mediation model, it's just at least one person who looks like you. It doesn't have to be the pair. And then with that, there's I think the idea of having a diverse roster for a court system, probably for any program, but I'll speak about the court system. I think that's critical. It's very important to have a diverse roster. Then there's the idea with selection, which you just spoke of. How do you get the cases to which mediators? On district court day of trial, for example, it's the neutral who signed up that day, and you don't know who it's going to be. You don't know if they're going to be an attorney or a non-attorney, male, female, black, white, or what have you. You just don't know who it's going to be. Maybe there's an adjustment that needs to be made in the program there. I'm not sure. It's a question to ask. It's a lead to follow. Then you also have the tension of how big do you want your roster to be. If you've got a roster of 200 practitioners and you're sending each one of them only 4 cases a year, and they're not getting cases from anywhere else because it might be hard to get cases from anywhere else, or maybe, dare I say it, they're not busting their butt to try and get more cases from anywhere else, just assuming that the court's going to keep sending them the cases. Now you've got practitioners who don't have a lot of experience. Tie that back into the research. One of the things that we learned is the practitioners who have had more cases within the immediate 12-month period prior to the one on which the day on which the survey was conducted tend to fare better in certain ways. There's also a negative correlation to that. So you've got to pay attention to all, and then somebody else mentioned intake and selection. The court rules allow for attorneys or their clients, although I suspect the attorneys are making all the decisions, to choose who they want. So the court may say mediator X is going to be your mediator, but you've got 30 days to choose your own if you want. The number of attorneys that I ask, how often do you select your own? They don't, right? They don't pay attention to that rule, or they don't go out and find an ADR practitioner that they like or that does a good job for them. Why is that? Why are attorneys not taking that initiative? Why are attorneys not talking to their clients about what it is that they want or need or that's going to work for them in a particular case? So I don't have answers to any of those, but I think they're all reasonable questions and reasonable things to be talking about and thinking about as we go forward.
I was just going to clarify on the racial match question. One of the things that's interesting, because you're talking about it in terms of who are people selecting or who are the attorneys selecting or attorneys saying what my client wants. So the way that this research was done, we didn't actually ask people what their perspective about racial match was. We asked them what their race was, and we asked the mediator what their race was, and we created a match variable based on that. And then we looked at their answers to the questions, and holding constant for what the mediator actually did in the mediation session, we found the connection between whether there was a racial match and what people's experiences were. And I think that's a really important distinction, because I think that you could say, oh, well, people think race match matters, but it doesn't, or they don't think it matters, and it does. It's really important to distinguish that what we looked at was there an objective match based on how people self-identified their race, not did they think it mattered. It would be an interesting survey, it would be an interesting study to see what people think matters. The other thing that I would say about that, though, is because the imbalance in the diversity in most of the panels that we're looking at is that they were primarily white mediators, and mediating in Baltimore City and Montgomery County, the mismatch was almost always that you had a white mediator and an African American or Latino participant. And so we don't actually know if we would find the same result if it were an African American mediator and a white participant, because really the result we have is from the mismatch being a white mediator, an African American, or a Latino participant. And the reason that that may be important, and this gets to, in our group we talked a little bit about, we know what this says, we don't know why, right? We don't know what's behind it. But it may be important because some of it may have to do with seeing someone who looks like me. So it may be that white mediators prefer white participants as well, white participants prefer white mediators as well. Or it could have to do with the broader structural power structures that we sort of function in, and so someone who has less general access to power in our society looking at someone who has more general access to power in our society. So we don't know the why, but I do think that it's a really important finding, and hopefully it, along with several other pieces, spurs additional research, because there's a lot more questions in there.
Yeah, I think that's important, because one thing that I do know is true, and I'm an example of it. Once you get in the room and you do a good job, people call you back. And I think it's regardless of who you are. And so my experience has been I've never had to advertise. And so I think if we can get people in the room who are good, that they will continue to get work. And so, got a question?
Well, it's more of a comment. Part of listening to this conversation is that the gender and the racial pool of mediators is going to be somewhat skewed, and that we need to look at this as an opportunity of reaching out to the younger attorneys and younger community to offer ADR training at a less or no fee cost basis, because I think sometimes the tuition to do a 40-hour mediation is absolutely a barrier for many of these folks, especially the young lawyers just coming out of law school. I see that in the district court. They're struggling, and they're doing whatever they can to volunteer to get some time in court. But the training, I think we need to look at from the court, whether it's a scholarship or other ways to make opportunities available for greater training of a wider, diverse pool.
Yeah, I think that's good thought. Anybody else before we, okay, I'd like to give our panel a round of applause. Oh, you got a question? Oh, hold it, you got a question?
It's really a comment, Marvin. I think this research is so important in so many different ways. for the structure of court programs, the administration of court programs, for practitioners, for lawyers, and many more implications, and certainly a basis for further research. But I wanted to say the thing that really touched me is that what first really inspired me to care about mediation was the idea of, and from the San Francisco boards, was the idea of empowering people, giving people voice, and changing the way people handle conflict, because our communities and our country are so, and the world are so ripped up by how conflict is handled destructively. And so to see, I've believed that those things happen with mediation, but to see it confirmed that reflection increases self-efficacy, actually empowers people, and that elicitive practice helps people approach conflict differently. It's just very gratifying to see those core things that I think are so important for the world confirmed in this research.
Thank you, Rachel. And that just means that we still have a lot of work to do. Some of us think that we're done, but we are just getting started, and we have a whole lot of work to do to not only we got to change this country state by state, and then we could change the world, but we still have a lot of work to do. Let's give our panel a round of applause. Jeff, 5 more minutes here, and then the next session starts at 1:30.
1:30.
Thank you.
Too late to get chocolate. Let's go back to lunch.
Nice getting to meet you.